Registrar, Victoria, any appearance for Unical Chapel?
Yes, my lord.
Yes.
My lord. SNH Andrew, my lord.
Yes.
I appear with my learned friends, Donald Archibald.
Donald Archibald.
I am Anana Abraham, sorry. I am Abraham.
Okay.
And Dr. C.N. Kokelu for the claimant, my lord.
Yes. Any other appearance? Any other appearance? Counsel, you have to unmute yourself. Unmute yourself.
Okay. Okay, my lord can hear me now?
Yes.
Okay, my lord, may I appear for the defendants?
Okay.
I am Bai Okweni, my lord. And my learned friends appearing with me.
Yes.
Mrs. Eno Edet Ajogbo.
Yes.
And Messi Okalo.
Lady Okalu.
Messi.
Okay, Messi Okalu.
Yes, my lord.
Yes.
For the defendants, my lord. Thank you, my lord.
Okay. Yes, what is how far about the settlement?
My lord, the settlement is still ongoing. Terms of settlement has been drawn up, but it has not yet been signed because of various engagements by the Vice Chancellor. So we would be asking for a further adjournment for the conclusion of that settlement process.
Okay. Yes, Lionel Sick. Mba.
What? Oh, yes, my lord. My lord, I'm surprised that it's my learned brother himself that is only aware of the settlement. I'm not aware of any settlement. Nobody has invited me. Nobody has put a call to me that there is a settlement of this matter. And then if there is settlement, why are the claimants going to other courts? Eh? I've not been invited for any settlements. Not even my learned brother Sol has invited me, has notified me that there is any settlement going on. We are not against settlement, but we should be honest about it if we want to settle.
Yes, learned Sikh Andrew, you heard what your learned friend has said?
Yes, my lord.
That he is not aware of any settlement. I think that was what council even told me at the last adjourned date. When this matter came up last, you mentioned that there was settlement negotiation for settlement ongoing, and council that appeared. I think on that day, edit appeared for the defense, and she told the court that she is not aware of any settlement, and I advise that any settlement must involve the council for both sides. So I'm surprised that up to now that the defense has not been contacted. Yes,
The settlement. And councils were not involved in the settlement. It was done by the VC with the parties. But from all indications, the defendants are not interested in that settlement. So if they don't want to see through the settlement, we are also ready to go on with our case. We have our processes before the court. We are ready.
Okay. But how can you do settlement behind the council?
My lord, I think,
my lord, sometimes that is the best way to settle. Because when the council get involved in the settlement, they start arguing law and not making peace. So in the settlement here, the VC was trying to mediate between the disputing parties.
Then how were you involved? If that is the case, then you shouldn't have been involved.
How was he involved?
You shouldn't have been aware also.
My lord, I wasn't involved, but my client briefed me on the settlement that is going on.
Okay.
Yes, my lord.
Where is the defendant? Is he online?
My lord, the defendants are here.
Are they online?
Yes, my lord, they are. Okay, you can talk from there.
Who is Reverend Joseph?
Yes, sir, present.
Yes. The counsel for the claimant said that there is move for settlement, which is being geared by the Vice Chancellor. Is it true? And you were involved?
Please, sir, we were invited for a meeting with the Vice Chancellor.
Okay.
We were not informed that that is part of any process towards out-of-court settlement.
Okay.
What happened?
And then after that meeting, we have not been invited for any follow-up.
Okay.
So, to the best of our knowledge, there is no process or no activity geared towards the out-of-court settlement.
My lord.
Yes, I'm still writing.
It's okay, my lord. It's okay, my lord. When you are through, I want to make a brief comment. And there's a court sitting going.
Yes, Lionel, let me hear you before I
Yes, my lord.
read what
My lord,
I have put down.
yes, my lord. I said I should make it clear and let it be on record that we are not opposed to any genuine approach to settlement of this matter. The former vice chancellor of the university made a lot of effort to have this matter resolved. But the people who are behind the institution of this action refused and frustrated all efforts to do so. I encourage the defendants and all others to work towards the settlement. It is the people behind the institution of this action that refused the settlement and rather decided to go to court. Even as we are here, as my lords have seen, while they are talking of settlement, they have gone to the Federal High Court. Is that in the spirit of a person who wants to settle a matter? So if they are minded to have a proper settlement and resolution of the dispute, we are in support of it. But everybody should be honest about it. So that is my position, my lord.
Yes, this is what
it's not a hide and seek matter.
My lord, in response to what my learned friend has said, I also support settlement in this matter. And I've been encouraging my clients in that direction. The case in the Federal High Court is on a completely different issue. The summons is before your lordship already. So, my lord, if my learned friend is sincere about this settlement, he should allow the VC to conclude the process he has started. That is our position, my lord.
VC has not called us. VC has not called them. It was only one. If he's having meeting with your clients alone, we should know. I'm not aware. How will there be genuine settlement in a matter that both of us are involved in? Lawyers are involved in, and the lawyers do not know about what is going on. I don't accept the proposition that the lawyers
had meeting with our client alone. When your client is saying here that he had a meeting with the VC, he was there at the meeting with the VC.
He was invited for a meeting, not for settlement of this matter. They were invited for a meeting.
What was it for? If it wasn't for settlement of this matter, what was it for?
They did not know. The vice chancellor invited them. Are they not staff of the university? They are all staff of the university. So if the vice chancellor invites them, they will have to go. And in any event, the vice chancellor, from what I gather, was giving a matching order for matters to be withdrawn. We have not filed any case. It is you who have filed all the matters. We have not filed one single case. We are only defending.
Yes, counsel, this is what I put down.
Okay, my lord.
After listening to submissions of counsel for both sides and the first defendant who is in court virtually, it appears to me something is amiss because the learned senior counsel for the claimant has at the last adjourned informed the court. The learned counsel for the claimant has informed the court at the last adjourned that there is move for settlement, and the counsel for the defendant promptly informed the court that he is not aware of any move for settlement. The court then intervened and ordered counsel that the settlement should involve both parties. It is the same story today, that the first defendant is still not aware of any move for settlement, even that the defendants are still not aware of any move for settlement, are not aware of any move for settlement, and even the defendant who appears virtually also informed the court that he is not aware. He was only invited for a meeting at the Vice Chancellor's office, and he was not told that it is for settlement in respect of the matter. This means that something is fishy, and the court cannot continue to be granting adjournment for a proposed settlement that the parties are not committed to. And the court, because settlement cannot be done one-sided, it has to be by consent of both parties. Whatever settlement that was reached, it has to be by consensus. In the circumstances, I have no choice than to continue with the hearing of this matter. In fact, at the last adjourned date, the order of the court was that if there is no progress on the settlement today, hearing will continue. In the circumstances, hearing shall continue now.
As the court pleases.
Yes.
My Lord, we have a number of motions.
Yes. How many motions do you have?
My Lord, the main motion is for stay of proceedings. Then there are motions for extension of time. May we start with the motion for stay of proceedings?
Is there any appeal against any of my orders?
No, my Lord.
So how can I grant stay when there is no appeal?
My Lord, this is not
is it possible to grant stay when there is no appeal?
My Lord, application is not for stay pending appeal. It is to stay pending the outcome of another suit.
Under which law? Under which law? Under which law that permits that kind of application? Which law permits that kind of application? That the matter is pending before me, that I should stop it until another matter is decided, which is not before the Court of Appeal.
My Lord, an issue has been raised in this suit which is not within the jurisdiction of this court to determine. And that issue is within the exclusive jurisdiction of the Federal High Court.
You go to the court that has jurisdiction so that you can sort out yourself. And you allow me to decide what you brought before me.
As the court pleases.
As the court pleases. So,
well, in any event, I will hear you. I will hear you. I will rule. I will take all the pending applications. Now, I will take whatever is pending before me. Then I will rule at the same time.
As the court pleases.
As the court pleases. Yes, my Lord. We have a motion for stay of proceedings of this suit pending the determination.
When was it filed?
My Lord, the motion was filed on the 9th of March, 2026.
Yes.
My Lord, we have we filed our counter affidavit in opposition to that motion out of time. And we filed a motion on 24th March 2026 to regularize that counter affidavit, my Lord. If my learned friend
yes
is taking the motion, may we take our motion to regularize the counter affidavit?
Yes.
My Lord, we have been served with the motion for extension of time to regularize the
let him go ahead and move it first. He should have. He shouldn't have even allowed you to start. He should have moved it first. Yes,
my Lord. My Lord, The motion is dated the 18th day of March 2026 and filed on the 24th day of March 2026. There are two prayers on the motion paper.
Yes.
The first is for my Lord to extend time within which the defendant's applicant to file a counter affidavit and written address in opposition to the motion of 9/3/2026. That's the motion for stay of proceedings.
Yes.
And the second is for my Lord to deem the counter affidavit and written address already filed on the 23rd day of March 2026.
Yes. Have you served it on the other counsel?
My Lord, they were duly served.
Lanesik, are you objecting?
No objection, my Lord.
Thank you, my Lord, and I thank my learned
Application
brother,
granted as spread.
as a court, please.
Yes. Which other application?
My Lord, since my learned friend has regularized his response to my motion for stay, may I move the motion for stay?
Yes.
Then you have another motion for extension of time.
Okay, my Lord, I have a motion for extension of time in respect of another application.
Yes.
My Lord, it was filed on the 23rd of March, 2026.
Yes.
And we are seeking for extension of time to respond to the defendant's further and better affidavit, and to deem a further and better affidavit as properly filed. May we move in terms of the motion?
Yes.
My Lord, we do not oppose that application.
Okay. The motion on notice filed on the 23rd day of March 2026, having not been objected to, is hereby granted as spread.
As the court, please.
Yes. Yes,
My Lord, we go back to our motion for stay.
Yes.
My Lord, it was filed on the 9th of March, 2025.
Yes.
It is supported by an affidavit of 6 paragraphs.
Yes.
Which annex 3 exhibits marked A to C.
Yes.
We also filed a written address,
Yes.
which we hereby adopt as an argument on this application.
Yes.
My Lord, the law is that a stay of proceedings is to be granted in exceptional circumstances.
Yes.
And what constitutes exceptional circumstances vary from case to case.
Yes.
But the object of a stay is always to promote the interest of justice.
Yes.
In this case, the defendants
Yes.
introduced the issue of the validity
Yes.
of the claimant's certificate of incorporation.
Yes.
That this case had been heard and adjourned for judgment.
Yes.
The validity of a certificate of incorporation is not an issue within the jurisdiction of this court.
Yes.
Therefore, your lordship cannot pronounce on it.
Yes.
It is a matter within the exclusive jurisdiction of the Federal High Court.
Yes.
Since it is the submission of the defendant
Yes.
that issue is relevant to this case,
Yes.
and your lordship agreed that it is relevant to the extent that your lordship stayed your judgment.
Yes.
For the parties to argue this particular issue.
Yes.
We submit that it is futile to argue that issue before this court.
Since the court has no jurisdiction. Anyway.
Yes.
Since the court has no
Counsel,
jurisdiction.
Counsel, I hope you are not repeating your written submissions.
No, my lord. We
What
submit
are
that
you
it is
doing then?
we submit that it is futile for the court to for the parties to argue this issue before this court.
My learned sake, you
Yes, my
cannot
lord.
be re-arguing your case since you have already argued it in the written address. All you need to do is to adopt it. Save
As
our
the court,
time.
as the court pleases.
Yes.
We adopt your address and respectfully urge your lordship to grant the motion as prayed.
Yes.
Yes, my lord, in opposition to that application for stay of proceedings, very strange application for stay of proceedings.
Yes.
We filed a counter affidavit of 17 paragraphs on the 23rd day of March 2026, my lord.
Yes.
Deposed by Joseph Akobi.
Yes.
There's a written address accompanying and in support of the counter affidavit.
Yes.
My lord, we rely on the counter affidavit in our opposition and adopt our written address in urging your lordship to dismiss the motion as being not just strange, my lord, but a very ridiculous one, with due respect. If my lord permits, let me make two statements that.
Yes.
My lord, the first is that in our jurisprudence,
yes,
a stay of proceedings is only considered and granted when there is a pending appeal, my lord. When there is a pending appeal.
Yes.
The second point we make, my lord, is that it looks strange that the very claimants who have brought the case before the court are the ones now seeking to stay proceedings in the determination of their own matter.
Yes.
And what makes it more ridiculous is that my lord is to stay proceeding pending a new matter they have filed during the pendency of this one and in the Federal High Court, a court of concurrent jurisdiction. A court of concurrent jurisdiction. And as if you are bound by the decision of the Federal High Court.
Yes.
My lord can only stay proceedings if there is an appeal and the determination of that appeal will affect the substance of the matter before your lordship. Proceedings cannot be stayed pending the determination of a matter in another court of concurrent jurisdiction, which decision may at best be persuasive to my lord, not binding on your lordship. So we've adopted our written address.
Yes.
My lord has a case before you, and it is the determination of the case before you that my lord is enjoined by law to do. It is not the determination of a matter that is before another court, my lord. So that's our submission. May the motion be dismissed, my lord. And it will not be out of place for us to ask for reasonable cost, my lord, for this delay. Thank you, my lord.
We have some additional authorities to give you a lordship. You can
send it. You can send it. You can send the additional authorities. The additional authorities and send it to counsel for the other party.
Yes, my lord. My lord, we will also send.
Yes, my lord.
My lord,
additional authority is on the point that the state can be granted pending the outcome of another suit in another court, concurrent jurisdiction, which is the issue he has raised in his address. I have two authorities on that point.
My lord, I also have an authority in a matter I have done at the Court of
Appeal. Counsel, we cannot continue to be going forward and backward.
The court, please,
you have the opportunity to file all your addresses and cite all the cases you want.
That is so, my lord. That's so, my lord. We leave it there.
Whatever you have, if you have additional authority, I have given you permission, file it in court and serve the other party.
As the court pleases, we will do so.
My lord, we will need my lord's direction.
You say?
My lord, we will need your lordship's direction with regards to the substantive matter.
Have you not argued the substantive matter? I'm going to take everything at once.
Yes, my lord, that's
what I want to get. I'm going to write judgment, and all the rulings will be contained in the judgment.
As the court pleases.
My lord, we've not adopted the new processes we filed.
And you can go ahead and adopt it now.
That is so, my lord.
Because I'm not giving you any adjournment again.
It's okay, my lord. That is what I wanted
for judgment now. So in
It's
my
okay, my lord.
judgment,
Wait.
all the application will be dealt with.
It's okay, my lord.
All
Okay.
the stay and whatever.
We file a further.
Okay.
Yes.
My lord, for the claimant will start first.
My
Yes.
Lord, it is the defendant that will start. We had argued
problem.
this case and it was adjourned for judgment. On the day
Yes.
for judgment, the defendant raised a new issue. So
Yes.
it is this new issue that is now to be argued. So he will argue his new issue. I will respond.
It's okay,
Yes.
my lord. My lord, we filed a further counter affidavit in opposition to the originating summons on the 27th day of January 2026.
Yes.
It contains 11 paragraphs, and it is deposed to by the second defendant, my lord. Accompanying the further counter affidavit are two exhibits, my lord, which
Yes.
we marked as the D18 and D19 respectively.
Yes.
Exhibit D18 is our petition to the Registrar General of the Corporate Affairs Commission while Exhibit D19 is the response of the Registrar General of the Corporate Affairs Commission. Lord, we have a brief written address accompanying the counter affidavit, which with my Lord's leave, we hereby adopt and rely on the further counter affidavit and the two exhibits attached. The only point, if my Lord permits, that we will converse, and which is also relevant to the motion, or stay, is that the main issue raised by us, one of the major issues raised by us, is the issue of not having a proper claimant before the court. Not having a proper claimant before the court. So the matter that has been filed at the Federal High Court cannot give a proper claimant when there was none at the time of the filing of the case, my Lord. So there is no proper claimant. We've brought to the attention that we are in charge. So all documents should emanate from us. During the time of the people who are sponsoring this dispute, we never interfered in the running of the affairs. So they can't go behind. They cannot go behind to start seeking legitimacy when they are no more in office. And we said the action they are challenging is the action of the congregation. And we have maintained that the congregation owns the church, not few dissident individuals who have lost election and do not want to leave offices.
All these arguments have been canvassed by analysis.
So let's
be able
to uphold that point we have raised and then dismiss the suit before you. Thank you, my Lord.
Yes, Lanesi. Yes.
My Lord, in response to the further affidavit, further counter affidavit of the defendant.
Yes.
The claimant filed a further and better affidavit on the 23rd of March, 2026. And it was deemed as properly filed and served this morning.
Yes.
My Lord, in support of that further and better affidavit, we filed a reply.
Okay.
on points of law
Yes.
to the submission of my learned friend
Yes.
that the claimant on record does not have local standard.
Yes.
We adopt them
Yes.
and urge your lordship to discountenance that objection. More so,
Yes.
since the purported loss of locus happened during the pendency of this suit and not at the time the suit was filed.
Mm-hmm.
They had it from the beginning. They had him from the beginning. Yes, they had him from. They're just trying to.
We
Yes.
urge the Lord to grant their prayers on our legislative summons as prayer. Let so please your lordship.
Lanesik, by this submission, you are admitting that you have lost locus
As the court pleases.
when this matter is pending.
As the court
No,
pleases.
my lord. I said more so since the purported loss of locus, according to the defendant, happened during the pendency of this suit. That is what they said in their further counter affidavit.
Okay.
They said during the pendency of this suit, the claimant has lost locus to bring the action.
No,
and the law is that locus is to be established as a threshold issue at the commencement of the action.
Yes.
In any event, that issue of locus standi is not an issue the defendant can raise in his own counter affidavit. Locus standi is determined based on the averment of the claimant.
And what is the abatement in this case? This is an originating summons.
Yes, my lord. In
It
an
is
originating
the
summons,
affidavit that is the pleadings.
yes, my lord. In an originating summons, the affidavit is the pleading. And
Yes.
local standard is to be determined based on that affidavit. And the deposition in affidavit is that the claimant is duly incorporated. We have exhibited the certificate of incorporation.
It's all right.
Yes, ma'am.
But you've always maintained that. You've always maintained that the suit was not properly constituted and cannot sustain the case from the beginning.
This case is hereby adjourned to 14th of May 2026 for judgment and ruling on stay of proceedings. Yes, May 14th.
As the court pleases.
As the court
As the court pleases.
Yes, registrar, call the next case.
I'm sorry, my lord.
Yes.
Did I hear you correctly? 14th of May.
Yes, May 14th.
Okay, as the court pleases. Thank you very much.
Okay.
Suit number NICN CA06-2026 between 1. Comrade Achibong Okon Effiong 2, Comrade Joseph Eteng. 3, Comrade Richard Itaita. 4, Comrade Dr. Patrick Ndem. 5, Comrade Nsika Rabasi Umo. 6, Comrade Mrs. Florence Orok. 7, Comrade Egan Ndem. 8, Comrade Michael Omashi. 9, Comrade Enu Patrick Odu. 10, Comrade Cosmos Emori. And 1, Registered Trustees of Senior Staff Association of Nigerian Universities, SANU. 2, Mr. Emmanuel Ntiga Otu, Chairperson, Senior Staff Association of Nigerian Universities, Unical Branch. 3, Mr. Egba Ebenezer Egba, for himself and all members of the Branch Election Credentials Committee, Senior Staff Association of Nigerian Universities, Unical Branch. My Lord, all
Yes.
the parties.
The first applicant is present. The first claimant.
Yes.
Comrade Achibong Okonifo.
Where is he? Where is the first claimant?
He is on my screen, sir.
Yes. Any other
Yes, sir.
party present?
My Lord, other
Any
parties
other
are
party
absent.
present?
My Lord, they are
Other
absent.
Appearance.
parties
Other
are
claimants
absent.
are absent. The
Appearance.
defendants are absent, my Lord.
Appearance.
May it please your noble lordship.
Yes.
Ibn Esquire appear for the claimants. We apologize for the absence of the other claimants, except the
Yes.
first claimant.
Yes. Any other appearance? Any other appearance? Any other appearance? Appearance for the dependents?
My Lord, Dr. Ebo was online. Maybe, I don't know what happened.
I have
Dr.
not
Ebo
seen him.
was online.
I can't see him online.
He was either the
Dr. Ebo,
first or the
please.
second person.
Dr. Ebo, unmute yourself, please.
Yes, please, counsel, unmute yourself. Unmute yourself. We can't hear you because your speaker is muted. Your speaker is still muted. Unmute yourself. Touch the screen. Then you touch the speaker.
Unmute
Touch
yourself,
the
Dr.
screen.
Ebo, please.
Unmute yourself. We can't hear you until you unmute yourself. Please seek the assistance of somebody that is there who knows how to unmute. If you don't know how to unmute, just touch your screen. You will see a red. Unmute yourself, counsel. Hey. We can't hear you until you unmute yourself. Please unmute yourself.
He has been unmuted,
Yes.
sir.
Yes, my Lord.
Yes. Yes.
My Lord, with profound humility,
Yes.
Sam is my name. I appear for the second and third defendants, sir. Yes, sir.
Yes.
My Lord, I apologize for the absence of the second and third. They attended the national meeting of this organization, or the first
Yes.
defendants.
Any other appearance?
My Lord, Neil.
What of the first dependent? No appearance for first dependent?
Well,
Yes,
my
sir.
Lord, we felt that they have not been served. We wouldn't know because they didn't communicate with us.
My Lord, there is
Yes.
proof of service of all processes on the first defendant before the court.
Yes.
My Lord, we
Yes.
have information for the court.
Yeah. Okay.
On the, yes, sir, on the 17th day of March, My clients communicated to me that the Vice Chancellor of the University of Calabar have intervened in the Sanu situation. And parties met, the Unical branch, and the claimant had a meeting and tried to resolve their impasse. My Lord, as at yesterday, I was furnished with a written resolution emanating from that meeting. And I also informed my learned friend on the other side of that development.
Okay.
My Lord, I advise parties to draw up terms so that we can file terms of settlement before your lordship.
Okay.
But what they sent to me as we speak is what the title resolution of the meeting held between the parties. My Lord, I'm going to send this over to my learned friend so we draw up terms of settlement and file before the courts.
It's all right.
Yes, sir.
Yes, Mr. Ebu.
Well, my Lord, we are also amenable to settlement on our own side. I met with my learned friend a few days ago. He merely mentioned it. We have not received any document to that effect. So we are waiting, sir. We are waiting, sir. Yes, sir.
So what do you want now?
Well, my Lord, we will indulge them. If they come up with the terms of settlement, we will go with it.
How long adjournment do you want, Mr. Etin, for you to conclude and file the terms of settlement?
My Lord, from the resolutions, we are going to draw up the terms. My Lord, within 2 weeks, that should be filed and done.
Yes, Registrar, give me date.
My Lord, April 28th.
No, it's fine now. They said they need only 2 weeks.
Yes, my Lord.
Okay.
Check your record.
Lord,
second week of April. When are we sitting? When are we starting sitting after vacation?
My Lord, we are starting on the 14th, but that 14 is
No, that
congested.
week I think the NBA has written to us that we should.
Yes.
We should
15 to
now
19.
they are going to have their NBA week.
Yeah, about week, yes, sir.
The week after that one, give me a date. The week
My Lord,
after the NBA.
My Lord, 21, 22, 23 is not convenient, my Lord.
No, it's just settlement. You can fix it any day. It's for them to adopt their terms of settlement. It's not hearing.
Okay, my Lord. My Lord, 21st of April.
Counsel, is it convenient for you?
Yes, my Lord. Yes, my Lord, is convenient to the defendants.
Mr. Eti?
My Lord, please, I had a interference on my internet. Please, what date, sir?
21st. April 21.
Sorry, 23rd. 21.
Yes. Is it convenient for you?
My Lord will take it. We'll take it. My Lord will take it, but it's not convenient. We'll see how we can. We'll take it, sir.
Okay. This case is hereby adjourned to 21st day of April 2026 for adoption of terms of settlement.
As the
Lord places. Lord, we are grateful.
Yes, Registrar, call the next case.
Yes, my Lord. Suit number NICN CA 46 2024 between Mr. Akor Mohammed Hosani. 2. Mr. Rufus Abiodun. 3. Mr. Adeboye Bamidele. And 1. Mr. Kelvin Tiku Agbo. 2. Truck Lock International Nigeria Limited. 3. Mr. Efium Ekpenyon for Lafarge Africa PLC. My lord, the parties are absent.
Appearance. Appearance. Any appearance for NICN/46? Are they aware of today's date?
Yes, my lord, very much aware. They are, my lord.
Parties absent and no legal representation. This matter is for judgment. The judgment is ready and it will be read shortly.
As the court pleases.
This is the judgment of the court. The claimants were employed by the second defendant as delivery officers with effect from 14th day of March 2022. However, sometimes in December 2022, Raji Rasaki, an employee of the second defendant and colleague of the claimants, attempted to get into the post-dependent facility to load cement as usual, but was denied entry because his security access had been blocked. When he tried to find out why, he was told by the security men on duty to check with his company, that is the second defendant. And he was also informed that same action has been implemented on other 5 employees of the second defendant, which included the claimants in this case. When the claimants all discovered that they suffered from the same predicament, they approached the first defendant, who is the manager, seeking an explanation for action of the first defendant, since all the disciplinary action always involve active involvement of the employer, but they got no satisfactory explanation. According to the claimant, they later learned from other colleagues who saw them pleading with the third defendant to know what crime they had committed to have been denied access by the first defendant to be denied access. According to the claimants, the first defendant had leveraged his relationship with the third defendant, who served as a subordinate during his previous employment with the first defendant, to get them blocked on trumped up allegations that the claimants were forming a union of drivers to sabotage the operation of the post defendant, which allegation was false, vindictive, malicious, and deliberately calculated at damaging the relationship between the claimant and the post defendant, and jeopardize the opportunity of the claimants operating within the facility of the post defendant. The claimant stated that they were left in the dark on the situation as no query was issued to them, nor were they made to face any disciplinary panel. Neither was their employment terminated. They were just constructively disengaged. After meeting the owner of the second defendant in Lagos and hearing from them, the claimants were asked to go back to Calabar to apologize to the first defendant, even though no disclosure was made to them on the nature or particulars of any complaint, infraction, or grievance of the defendant against them, and promised that the restriction of their security access into the post defendant will be lifted. The claimant apologized as directed, but nothing changed as the situation remained unresolved. According to claimants, they have severally called the first defendant, begging for leniency and lifting of restriction of their access to post-dependent premises, or even sack them if necessary. For this period, they had been rendered redundant and they were only paid 1 month's salary in January 2024. According to the claimants who submitted petition to the police against the first defendant on the false and malicious information that resulted in their plight. In the course of police investigation, the first defendant stated that because unionism among drivers, the operation of the post defendant has suffered some setback in the southwest. As such, a mail had been sent to the third defendant requesting the staff numbers of drivers who are likely to cause disturbances to the operation of the post defendant. That since the claimant has some disciplinary issues, their staff numbers were forwarded. The restriction on the claimant is still subsisting. The claimant had been without work and they cannot find another work. According to the claimant, they stopped receiving their salaries as provided for in their contract of employment since December 2022 to December 2023, when the said access became restricted. And claimants were rendered redundant except for January 2024 salaries. The claimants were not paid salaries for a total of 13 months, amounting or culminating into 1,530,000 naira. The claimants have also not been paid their leave allowances since they commenced their employment with the dependent, which is 48,000 naira per annum from the date of employment, which is 14th of March 2022 until date, amounting to cumulatively 288,000 naira. The claimant, based on the above facts, filed this suit on 28th of June 2014 via a general form of complaint, wherein, as per paragraph 21 of the statement of facts, they claim as follows: a declaration that the information provided by the first and second to third and fourth defendant that the claimant were forming a union to sabotage fourth defendant business activity is unfounded, malicious, and false. 2. An order of court that the fourth defendant removes the restriction placed on the claimants on her access security system, its decision having been predicated on false and malicious information supplied by the first and second defendant. 3. A declaration that the second defendant breached the terms of the contract of employment by failing to pay claimants their gross monthly salary since December 2022. 4. An order of court compelling second defendant to pay the claimants jointly the sum of 1,530,000 being gross salary for the claimant for the month of December 2023 till date. 5. A declaration that the second defendant breached terms of contract of employment by failing to pay the claimant their annual leave allowances, which became payable on 14th day of March 2023. An order of court compelling the second defendant to pay the claimant jointly the sum of 288,000 being their leave allowances. An order of court compelling the second defendant to pay claimant jointly the sum of 288,000 cumulatively as being their leave allowances. 7. The sum of 30 million naira as against the first to third dependent as punitive and or exemplary damages for the distress, financial hardship, and psychological hurt caused the claimants arising from the conduct of first, second, and third dependent in providing malicious and false information to the first dependent, which rendered claimant redundant and withholding the entitlement of the claimant for its own use and profit. 9. The sum of 1 million naira as cost of this action. The defendant, despite proof of being served with all the originating process commencing this suit and hearing notices, they did not deem it fit and appropriate to enter appearance and or file defense to the claims of the claimants. The claimants, in the attempt to prove their case, called two witnesses. The first claimant, who testified as CW1, and Inspector John Iboro, who was subpoenaed, testified as CW2. The two witnesses adopted their respective witnesses' statement on oath as their evidence in this case. The defendants were absent and were not represented by counsel during the trial. Consequently, the two witnesses were not cross-examined after their testimony. On 29th day of January 2026, Philip A. Ofla Esquire adopted the final written address of the claimant. In the written address, a single issue was formulated for resolution, to which, whether considering the totality of evidence before the court, the claimants have proved their case in order to be entitled to relief sought. In arguing the sole issue, counsel submitted that the claimants, in proof of their case, called two witnesses and tendered exhibit ABC to prove that their employment letters to prove their employment with the second defendant. Exhibit D is the petition written to the police on behalf of the claimant by their counsel. Exhibit E is the letter of apologies that claimants wrote to the first defendant as directed by the owner of the second defendant. It is the submission of counsel that evidence was also laid by the subpoena witness from the Nigerian police, who tendered Exhibit H, first claimant's statement made at the police station, and first defendant's statement provided at the police station, all shedding light on the facts and circumstances of the case. Counsel refers to Section 17, subsection 1 of the Labour Act, and submitted that it mandates prompt payment of wages. Counsel contended that the second defendant's failure to pay salaries for 13 months without dismissal constitute a fundamental breach of the contract of employment. To support this submission, counsel relied on the case of Chukuma versus SPDC Limited, where the Supreme Court held that withholding salaries without justification is unlawful. As shown in the letters of employment of the claimants, they are entitled to 40,000 monthly as contained in paragraph 19 of the statement of facts. The second defendant has not paid them their salary from the period of December 2022 to December 2023. This is in addition to their leave allowances that has never been paid to them since they were employed. According to counsel, the information passed on the first and second defendant to the third and fourth defendant were trying to form a union of trailer drivers to sabotage the business of the fourth defendant. Knowing said to be injurious can also be established by Exhibit G, tendered by the subpoena witness. This exhibit contains statement made by the first defendant to the police upon petition of the claimant, as seen in Exhibit D. As will be observed in the said Exhibit G, the first defendant, acting in concert with the second defendant, went as far as admitting responsibility for the blacklisting of the claimant from the facility of the first defendant, and wrongfully so by the father stating that he was making effort to get their names off the blacklist. For ease of reference, that portion was reproduced by counsel, which read, I was given the instruction by my chief executive officer to supply the sub numbers of the affected drivers to La Farge, and I was only doing my job. I have on my own gone a long way to plead with La Farge to unlock these drivers, which they have promised to do so. He further confirmed that the claimants have done nothing wrong when he said, unquote, in my company, we have disciplinary action taken on any errant staff. No action was taken on any staff based on this case involved. Counsel submitted that the second defendant is the employer of the claimant and ought to have commenced a disciplinary action against the claimant dismiss them if there is evidence of wrongdoing before forwarding their sub numbers to the post defendant where the violation are very grievous, when the violation are very grievous. But as clearly admitted above, no such step was taken. The claimants never had any opportunity to know what was wrong. They had committed what wrong they have committed, nor was an opportunity offered them to tell their own side of the story. According to counsel, the claimants were denied fair hearing. To support this submission, counsel relied on the landmark case of Garba versus University of Maiduguri, where the Supreme Court held that denial of fair hearing as flagrantly emblematic of the instant case, rendered any disciplinary action, including blacklisting of claimant null and void. Counsel asked the court to so hold. Counsel further relied on the case of Olasu Kami versus UBN PLC Union Bank as per Adebukola Adeoti Iboranke Banjoko JSC, where she stated thus, to satisfy the rule of natural justice and fair hearing, an employee likely to be affected by disciplinary proceeding or action is entitled to be notified of the alleged allegation against him to enable him defend himself against the allegation. As clearly admitted by the first defendant, no disciplinary processes was instituted against the claimant. Thus, the submission of names of claimants to the first defendant was arbitrary, malicious, and made in very bad faith, which has not only rendered the claimant jobless but also unemployable, as the claimant have not been able to secure any alternative job. The first defendant have been the largest employer of labor for truck drivers in the axis, as well as emotional distress for their families and dependents. This is an injustice which the court is under duty to intervene by grant of the relief sought. On the failure of the defendant to defend this suit, counsel contended that the failure of the defendant to file defense amount to an admission of facts contained in the case of the claimant. He relied on the case of Federal University of Technology, Mina, and others versus Olutayo. Counsel also contended that, as record will show, the defendants have been served with the originating process and several hearing notices. Their failure to appear in court or cause statement of defense to be filed on behalf of the defendants, they are deemed to have admitted the case of the claimants. In concluding his submission, counsel asked the court to find that the failure of the first second defendant to pay salaries of claimant for 13 months and the annual leave allowances per terms or letter of employment is wrongful. 2, that the blacklisting of the claimants by the first defendant at instigation and false information of the first and second defendant is unfounded, malicious, and wrongful. That the claimants are entitled to the relief sought. Court decision. I have considered the processes filed in this case, the evidence adduced at the trial, as well as the written and oral submissions of counsel for the claimant. As pointed out earlier, defendants, despite having been served with the originating process commencing the suit and hearing notices, decided not to file any response or even appear to be or represented by counsel at the trial. The natural consequences of failure or neglect to file statement of defense in answer to the claimant's pleadings are that they are taken to have admitted, and all the abatements contained in the claimant's pleadings are taken as unchallenged, so long as they disclose a course of action. Thus, the failure of the defendant to file statement of defense in answer to the pleading of the claimant, they are deemed to have admitted the claims or reliefs in the statement of facts. The action of the defendant in refusing to file defense may warrant entry of judgment on the stance of the claim of the claimant. However, it is not in all cases where the defendant have failed to file defense that claimants would be entitled to judgment against the defendant. The peculiar facts of the case are to determine The peculiar fact of the case are determining factor to be taken into consideration by the court. A court should not enter judgment in default of defense where there is claim for damages, as in this case. Also, the law still requires claimant to meet up with minimal proof for them to be entitled to judgment. The rule by the minimal evidential requirement is that a claimant cannot assume that he is entitled to automatic judgment just because the other party did not adduce evidence before the trial court. See the case of Lawrence Azenebo versus Bayero University, Kano. See also Ogunyade versus Oshun K. Though it is a rule of pleading which is not denied, is deemed to have admitted. This means where a claimant filed statement of fact and the defendant did not file statement in answer thereto, he clearly will be deemed to have admitted the statement of claim, leaving the trial court with authority to preemptorily enter judgment for the claimant without having evidence, without hearing evidence. However, in law, to every general rule there is exception. The exception to this rule is when claims for damages is an issue, or where the claimant is seeking for declaratory relief. By law, a claimant seeking for declaratory relief must prove his case on the strength of his evidence, not on the weakness of the defense of the defendant, or even on admission. See Okereke versus Umahi. See also Nisom Wike versus Peter Side and others. And a declaratory relief is never granted on the basis of admission or default of pleading. See the case of Bullet International Nigeria Limited versus Olani and another. It is also tried law that for award of damages, the onus is on the claimant to prove his entitlement to such damages by adducing cogent and credible evidence in support of such claims. See Imana versus Robinson. See also Umana versus Okweruwe. See Oluru Tumi versus Felicia Ige. See also Engineer Femi Sonuga and another versus the Ministry of Federal Capital Territory, Abuja. See also Bernard Okebo versus Police Council. There is no doubt the reliefs being sought are of a mixture of declarations, payment of unpaid salary, leave allowances, which are special damages claims. There are also other reliefs bordering on restriction of access to post-dependent premises and punitive damages. The claimant's case being for declaration and special damages, they must succeed on the strength of their case and not on admission or failure to file defense by the defendant. The counsel for the claimant has made heavy whether on discharge of burden of proof based on the fact that no defense was filed by the defendant. As pointed out earlier, the claimants are still required by law to prove entitlement to their claim. I shall now consider the reliefs of the claimant vis-a-vis the evidence adduced in support and see whether those reliefs can be granted. Reliefs 1 and 2, as per paragraph 21 of the statement of facts, are for declarations that the information provided by the first and second defendant to third and second defendant were that they were forming union to sabotage post-dependent businesses and founded malicious and false and on order directing post-dependent to remove restriction placed on the claimant. It is clear to me that the claimants reliefs on false and malicious information allegedly given to third and post-dependent, which led to placing restriction of claimants, thereby denying them access to post-dependent premises for them to perform their function as drivers, which led to the alleged constructive dismissal from service, clearly revealed thought of procuring breach of contract, otherwise known as inducing breach of contract or tortious interference with contractual relationship, which occurs when a third party intentionally causes one party to a contract to breach their contractual obligation to another party. This thought is rooted in the principles that parties should be able to enjoy the benefit of their contracts without without improper interference from outsiders. To establish liability for procuring breach of contract, a claimant must prove the following ingredients. There must be a subsisting and enforceable contract between the claimant and another party. The contract must be legally binding and valid. 2. The defendant, the third party, must have actual knowledge of existence of the contract. That is to say, the defendant must be aware that a contractual relationship exists. The defendant must have deliberately and intentionally induced, procured, or persuaded one of the contracting parties to breach the contract. This requires more than mere negligence or inadvertent involvement. There must be a deliberate act aimed at causing the breach. An actual breach of contract must have occurred as a result of the defendant's interference. If there is no breach, the tort cannot be established. The defendant conduct must be without lawful justification or excuse. If the defendant can demonstrate legitimate reason for their action, such exercising their own legal right or acting on the public interest, the claim may fail. And lastly, the claimant must have suffered loss or damages as a result of the breach induced by the defendant. This, this, this could include financial losses, loss of benefit expected under the contract, or other quantifiable harms. There is no doubt that there is a valid contract of service between the claimant and second defendant, and there is evidence that the first defendant, based on information received from first, second, and third defendant, did restrict claimants' access to their place of work, which culminated in breach of contract of service with the second defendant. From the evidence before the court, it is not the first defendant that induced or caused the breach of claimant's contract of service with the second defendant. The reason being that the alleged information that led to the restriction was supplied by the first and second defendant, who are the employees of the claimant. This means it is not the first defendant that induced the breach of claimant's contract of service. There is another hurdle in the way of the claimants, i.e., there is no contractual relationship between the first defendant and the claimants. Therefore, this court cannot grant relief 1 and 2 due to lack of existence of contractual relationship, as there is no contract granting claimants access to post-defendant premises. In the circumstances, reliefs 1 and 2 fail, same are hereby refused. For reliefs 3 and 4, the claimant are alleging breach of their contract of employment by the second defendant in failing to pay claimant salaries for 13 months since December 2022. In proof of the claimant tendered Exhibit A, B, and C, which are their letters of employment, which also contain the conditions or terms of their employment. The claimants were employed on the same date, on the same salary, on the same monthly salary of 40,000. There is no evidence adduced by the second defendant to deny or contradict the evidence given by the claimants on the non-payment of their salaries for 13 months. In the circumstances, reliefs 3 and 4 succeed, same are hereby granted. Or reliefs 4 and 5, which are on non-payment of annual leave, there is no contrary evidence adduced by the defendant to challenge the assertion of the claimants on leave allowances. However, by the Exhibit A, B, and C, this exhibit clearly, in unambiguous terms, stated that annual leave is 10% of basic salary and not and this exhibit did not state the basic salary of the claimant, who stated that the second claimant paid them January salary, did not state what the basic salary was and how much was paid to them. In the absence of evidence to establish the basic salary of the claimant, these reliefs fail and same are hereby refused, as the calculation of the claimant was made based on gross salary and not based on basic salary, as provided for in the conditions of service, Exhibit A, B, and C. There is also a world of difference between gross salary and basic salary. So the failure to prove the basic salary also means failure to prove entitlement to the state leave allowances. Relief 7 is for the sum of 30 million against payments to serve the dependent. This relief is an ancillary relief and it depends on grant of relief 1 and 2. The failure of relief 1 and 2 means also failure of relief 7, which is an ancillary relief to those reliefs. Relief 8 is for the sum of 1 million cost of action. The law is settled that cost of action is granted at the discretion of the court, and for a claimant asking for specific amount, like in this case, must adduce evidence in proof. There is no iota of evidence adduced by the claimant to prove that they expended the amount being claimed as cost. In the circumstances, they have failed to prove entitlement to the 30 million naira being claimed as cost. From the above, the claimant have succeeded only in proving reliefs 1, reliefs 3, 4. In the circumstances, those reliefs are hereby granted as paid. For avoidance of doubt, the claimants are entitled to payment of their unpaid 13-month salary in the sum of 1,530,000 naira. The dependents are hereby ordered to pay the claimant the said sum as their unpaid salaries. The claimant are also entitled to costs which are assessed in the sum of 500,000 naira. All monetary awards as per this judgment should be paid within 30 days from the date of this judgment, failing which simple interest of 10% shall apply per annum to the unpaid judgment sum. Judgment is hereby entered accordingly.
As the court pleases.
Yeah, okay. As the court pleases. Yeah? Which manner?
Yes, registrar, how many cases remain now?
Oh, my
My
judgment
lord
already,
is remaining one.
Okay. I will take a
the
little
workers.
break.
They had 13
Yes,
months. Yeah, so they should pay them the 13
Yes,
months salary
counsel
and pay
in
them
that matter, are they online?
this thing.
yes, my lord,
No,
they are.
another thing.
Okay.
My company also. So, and they should be paid within
Please
30 days
inform
of
them
this
that I will take a
ruling.
little break.
Otherwise, I
I
should
have
Yes, my
attract
lord.
extra
the
10%
judgment, I have
of
finished the
this thing.
judgment, but I just want to conclude.
But that of their leave, they
The
didn't show, they didn't grant that.
I want to
And then
conclude. There is one issue that
500,000
I want to
naira cost.
conclude. There's a little, it
But
will
that
take
of
me
their leave,
just 10
annual leave
or 15 minutes.
payment, they didn't show
Yes, my lord.
proof that there was
Thank
So I
you.
will take
nothing
a
to
break.
prove that
Maybe
that this is their
counsel,
basic
if they
salary,
can still remain
which
online,
and
they can still
that
remain.
annually is supposed to be
But if they
10%
want,
of the
Okay, my
basic
lord.
salary. And
they
since they
can take
didn't
a leave.
bring it as a proof,
Maybe let's see, now
he
it
didn't
is
allow that.
10:51. We can resume by 11:20.
And he also gave them
Yes, my lord.
the
To resume
30
11:20.
this thing.
11:20.
Yes, counsel
Yes, my
in
lord.
suit number NICN stroke 19 stroke 2025,
Yes,
Mary
my lord.
Solomon Ekpike. Please, I'm going to take a little leave, some minutes to conclude. I have finished the judgment, but there is one little area I want to reassess. So please, we will resume by 11:20 for the judgment to be delivered.
As the
Council
court
may
pleases.
decide to exit and they may decide to remain on. I will remain on, but I will not be available. I will mute my camera. I will mute
As
my
the court
camera
pleases.
and I will mute my also speaker.
Hello, respectfully, my lord. So we're having issues hearing.